Welcome to this hearing of the Judicial Committee of the Privy Council in an appeal from the Court of Appeal in Jamaica. This is a hearing which is being held remotely because of the restrictions to tackle the COVID pandemic. The appeal in the case of Powell and Spence concerns a question of procedure, namely whether a magistrate's court can remedy a defect in the commencement of legal proceedings for the forfeiture of cash under Section 79 of the Proceeds of Crime Act, or whether those proceedings are a nullity by virtue of that defect. The appellant, Inspector Powell, who is the applicant for an order of forfeiture, is represented today by Mr. Michael Hilton and Sundiata Gibbs. The respondents, who are interested parties, are represented by Mr. Senior Smith and Denise Senior Smith. Before inviting Mr. Hilton to present his appeal, I will introduce members of the board who are hearing the appeal. I am Lord Hodge and am presiding over this hearing. Lady Black. Lord Lloyd-Jones.
Hello.
Lord Sales.
Good afternoon.
Lord Hamlin.
Good afternoon.
It's afternoon with us, but in Jamaica it's 7 o'clock in the morning, so I will add good morning to that greeting. Mr. Hilton, I invite you now to present your appeal.
Good morning, my lord, my lords, my lady. Thank you. I must start with an apology and a correction. If I could ask your lords, my lords, to go to paragraph 16 of the appellant's written case, which is at page 81 of the electronic bundle.
Thank you.
There's a reference there to Order 36, Rule 19. It is actually Rule 23, not Rule 19. The correct reference is in paragraph 30, but in this paragraph, 19 is an error. I apologize.
Thank you very much.
I should bring something else to your lordship's attention. You will note that the first footnote in our case points out that resident magistrates are now known as parish judges. And for completeness, I should tell your lordships that in 2016, amending legislation was enacted that changed the name of the act to the Parish Courts Act, Judicature Parish Courts Act, and changed the name of the courts to parish courts.
Thank you.
So this actually happened in between, I think, the hearing of the appeal in the Court of Appeal and their judgment, although their judgment doesn't actually reflect it. Now, my lords and my lady, the issue in this appeal is whether the proceedings are a nullity, because the appellant started them with a document which described itself as a notice, as opposed to a plaint. And we submit that the starting point should be, what is the intent of the statute? Two sections in the Parish Courts Act are relevant. The first is section 143, which requires applicants to start actions by lodging a plaint, which should state certain information. And that section also provides that the plaint should be in such form as may be prescribed, or as nearly in such form as circumstances admit. The other section, which my lords, I'd ask you to go to, section 190, which is quoted in our case at paragraph 28, but it is at page 125 of the electronic bundle. Section 190. Now, this section gives the parish court judge the power to amend all defects and errors in the proceedings. You will note, my lord and my lady, that the section places no limits on this power. But the most important words may be the final phrase. In the final 3 lines of that section, it provides all such amendments as may be necessary for the purpose of determining the real question in controversy between the parties shall be made. So the section both creates the power and indicates the purpose for which it should be exercised. We submit that the intent of this legislation is plain. Claimants or applicants must provide certain information, certain relevant information, and the judge may and should cure any defects in order to address the real question in controversy. Now, the Court of Appeal said this power to amend only applies to matters properly commenced. That's the phrase they use in paragraph 38 of their decision. The interested parties and the parish court judge take a somewhat nuanced position. They accept that the judge can amend if a claimant uses the wrong form to commence proceedings, as long as the form he uses is itself a commencement form, but not if the form used is not a commencement form. So that's the position as I understand it, that both the Judge Staple, the parish judge, and the interested parties take. Now, there's nothing in section 190, in the authorities, or in principle to support the distinctions the interested party and the parish judge seek to make. None of the cases they cite make that distinction. And in fact, the reasons that the courts gave in those cases in our submission support the appellant's case and not the interested parties. And if I may, I will give 3 examples. Now, both the parish judge and the interested parties cite and distinguish your lordship's decision in the Eldermeyer case. Now, the Eldermeyer case is at tab 8 at page 341 of the electronic bundle. And what they say is that case can be distinguished because the document the appellant used in error, which was an originating summons as opposed to writ, that document was itself a commencement document. But there is nothing in the board's opinion to suggest that this was a relevant factor. Instead, the basis for the board's decision appears to be Lord Templeman's observation, and this is at page 345 of the electronic bundle, that the modern practice is to save expense without taking technical objection unless it is necessary to do so in order to produce fairness and clarification. And obviously, the board felt that that was not the case there. There was no basis to say that the proceedings were a nullity. Perhaps more significantly, my lord, the interested parties cite two cases which arguably contradict the point they seek to make. The first is Hannigan. And Hannigan, my lord, is at tab 9. Now, what happened in Hannigan is that the plaintiff used a form of petition that no longer existed. The rules that created it had been replaced, and the petition had been replaced by another document. And so, to use the interested parties phrase, it was not a commencement document. But the Court of Appeal nonetheless allowed the plaintiff's appeal, and Lord Justice Brooke said at paragraph 36, which is at page 355 of the electronic bundle, the factor which appears to me to be of paramount importance in this case is that the defendants and their solicitors knew exactly what was being claimed and why it was being claimed when the quirky petition was served on them. The other case, the final one for this purpose, is Harkness. And if I could ask your lordships to go to the interested parties' submissions to their written case at electronic bundle page 102, paragraph 23b. Now, in paragraph 23b, my learned friends say, in reference to Harkness, that the plaintiff issued a writ, which is a commencement document. But they are actually incorrect. The irregular document in that case was not a writ. And your lordships will see that if you go to the case itself, the judgment is at tab 10. And if you go to electronic bundle page 365 at letter D, at the start of Lord Justice Russell's judgment, at paragraph C to D, you will see that Lord Justice Russell points out there that the application ought to have been made by a summons, but it was in fact made by an affidavit. The only thing the appellant in that case filed to start the proceedings was an affidavit, plainly not a commencement document, but the court nonetheless treated it as an irregularity and not a nullity. My lord, the Chief Constable and Ansley Justice's case, which the appellant cites, we cite in our written case, and we cite that case, my lords, at paragraph 40 of our written case. This is the case involving the dog that attacked the police officer. The error in that case was arguably more significant than the one in the appeal your lordships are hearing. In that case, the officer laid on information instead of a complaint. Theoretically, that was a more significant error, because the defendant might have been misled into thinking it was a criminal prosecution and not a civil claim. But even in that case, the court held that it was apparent from the document that it was intended to initiate a civil complaint, and so the court treated the information as a complaint, despite the title the officer gave it. My Lord, Lord Justice K's reasoning in that case is particularly useful in making our point. He noted that the statute deliberately permitted informality, and the same can be said of the statute and the rule in the present appeal. In addition to the point I noted earlier about section 143, referring to using the form or as nearly in such form as circumstances permit, there is Rule 23, the rule I referred to at the start that had been cited in error. So Order 36, Rule 23, says that the exact prescribed form is not mandatory, and that a failure would not be fatal to the claim. The actual language, my lords, of the rule is non-compliance with any of these rules or with any rule or practice for the time being enforced shall not render any proceedings void unless the court shall so direct, but such proceeding may be set aside either wholly or in part as irregular, or amended or otherwise dealt with in such manner and upon such terms as the court should think fit. Plainly, my lord, indicating an intent that there should be informality in the courts at this level, not a court of pleading, and that the court should amend where appropriate to get to the real issues between the parties. What the learned parish court judge did, my lord, is exactly what the authorities he acknowledged said he shouldn't do. He focused on the form rather than the substance. My lord, the appellants, the interested parties case, make an interesting observation. And if I could ask you to go to paragraph 7 of the interested parties case, which is at page 96 of the electronic bundle. That paragraph starts with the submission that the appellant did not intend to commence an action and made no attempt to do so. My lord, my lord, you're muted. My lord, Lord Jones.
Which paragraph, please, Mr. Hilton?
Paragraph 7, my lord, I'm sorry. Paragraph 7.
Thank you.
At page 96. Yeah, so I said the interested parties say that the appellant did not intend to commence an action. But it would have been plain to the court and to the interested parties that what the appellant intended when she filed the notice, she intended to ask the court to make a forfeiture order. And she set out in detail in the supporting affidavits the grounds for that application. Similarly, it would have been plain to the court and to the appellant what the interested parties intended when they filed their notice. And it will not have escaped your lordships that two applications came before the trial judge, the parish judge, one by the appellant, one by the interested parties. Both were initiated by a notice as opposed to a plaint. Neither party took the point. The parish judge himself took the position that they were both nullities because they were not plaints, they were applications, they were notices. We submit that an originating document has two purposes. It must give the court and the respondent certain information, sufficient information for them to know what the matter is about, and it must cause the matter to come before the court. The appellant's application in this case achieved both. The interested parties accept in their written case that the application filed by the appellant contained all the information required by Section 143 of the Act. And your lordships can find that acceptance at paragraph 8 of the interested parties case, paragraph 8 at page 97. So they accept that it contained all the required information. And in fact, as I've said, they took no issue with the information, with the substance, with the content, or indeed the form at the hearing. My lords, in these circumstances, we invite the board to adopt the approach that their lordships recommended when the board heard the Alexandrine Austin case. And at that case, my lord, is cited and quoted in the appellant's written case at paragraphs 52 and 53. If I could conveniently take you there. At page 90 of the electronic bundle. Again, similar to their position in the Eldemire case, the lordships referred to the modern approach. And Lord Templeman's dictum, quoted in paragraph 53, the lordships are satisfied that if a premature action is irregular and the irregularity is of a kind, which, as in the instant case, was cured without amendment by the mere lapse of time, and which causes no prejudice to the defendant, there is no reason for the court to insist that the irregularity nullifies and invalidates the whole proceedings. In the following sentence, my lord, the modern approach is to treat an irregularity as a nullifying factor only if it causes substantial injustice. The lordships will note that that decision was almost 40 years ago, and that was then described as a modern practice. And even now, we have decisions which we say take us back perhaps a century before that. The irregularity in the present case, my lords, caused no injustice at all. We submit that the learned judge and the Court of Appeal were wrong to have treated the proceedings as a nullity. And my lord, subject to any questions you may have of me, for those reasons and for the reasons in our written case, we invite and respectfully ask your lordships to allow this appeal.
Mr. Hilton, thank you very much for your succinct submissions. I'll see if my colleagues wish to ask any questions. I don't see any hands going up. Thank you very much. Oh, Lord Lloyd-Jones.
Could I just raise one matter, Mr. Hilton?
Yes, my lord.
If it had been issued in the proper form, there was a fee payable. And the fee wasn't paid, was it?
Well, my lord,
Difference?
yes, I think not, my lord. And I have two observations. Well, first, I don't know whether the fee was in fact paid, although to be frank, I suspect it wasn't. But the practice of the courts, certainly in Jamaica, and I suspect elsewhere, is to require and accept an undertaking by the parties to pay the fee. And there's nothing to prevent the appellant from paying the fee at the hearing or even now.
Yes, thank you very much.
I'd also observe for completeness, my lords, that the section 143, which speaks to the initiation of the proceedings and what must be done, makes no mention of a fee. And indeed, there's no specific section as far as I could see that specifically says a particular fee is payable. Although I do accept that there is a fee payable, perhaps under some regulation.
Thank you, Mr. Hilton.
Okay.
Lord Sales.
Yes, Mr. Hilton, on that question, section 190, which is page 125 of the bundle, says that the magistrate can amend defects and so on, including upon such terms as the magistrate may, I think that should be deemed fit. So presumably, would this be right, that if the appeal were to be allowed, it ought to be on terms that the appellant should pay any fee that was payable if things had been done correctly?
I think that's right, my lord. Yes. It would have been a condition that the parish judge could have imposed, and certainly one that your lordship said.
Yes.
Yes, thank you.
Lord Hamlin.
Yes, so you refer to paragraph 7 of the interested parties case, which refers to an interlocutory application to continued detention. I'm not sure we have that. Can you just tell us what that was?
Yes, my lord. So that there was, under the act, when the officer detains funds, there is a fixed period during which he must either apply for an extension or return the funds. And there was such an application for an extension, which was allowed. And the point, of course, made is that the number that was applied to the application was first given by the court when that first application was brought, when the matter was first brought before the court. And then subsequent applications were given the same number.
So in your notice, you used that same number. Is that right?
Yes, my lord, we did. Your lordship still have noted that in our case, we describe that number as the plate number. And I should indicate two things that you will see in the record. When the parish judge gave his ruling, and this is at page 21 of the electronic bundle, you'll see that in the heading, well, perhaps I should first take it to page 8. So page 8 is the appellant's notice. And you'll see that in the heading, there is a PC 77 of 2010. Now, at page 21, when the parish judge gave his ruling, he described that in the heading to that document as an application number. But then on page 32, and this is the notice of appeal by way of case stated, which is signed by the parish judge and the appellant. That document described it as a plate number. So it seems there was some confusion as to.
But that number derived from a document you issued. The clerk, the registry didn't issue a new plate number, did it? Or any plate number?
It did not issue a new number, my lord. But I've shown you how it was treated and described. Correct. I think that point was one other thing, my lords. At page 3, there is the application by the interested parties. Page 3. And that document bore that same number, 77. But in later documents, the parish judge treated it as 104. It's not clear from the record how the change came about.
So where did 104 come from?
It's not clear from the record, my lord.
Right.
I can't tell. It appears for the first time on page 21, as far as I can see. And on both page 21 and page 32, the 104 appears. And it's curious that it's a number that is subsequent to the 77. Well, perhaps not curious, because it was later in time to the original application.
Any further questions for Mr. Hilton? No. Mr. Hilton, can I just clarify one matter with you? You were asked about the amendment of a defect on terms. If the board were to advise that the appeal were to succeed, would it be appropriate for the board to make the ruling as to whether the defect should be cured, or would it be proper for us to send it back to the parish court? Because no one has as yet exercised a discretion in that regard.
Well, my lord, I think that it would be appropriate for the board to direct the amendment, because the circumstances that the court would take into account in exercising the discretion are all before the court, are not in dispute. And it is difficult to see on what other basis the discretion could be, or how else the discretion could be exercised.
Thank you.
Okay,
Thank you very much. Mr. Senior Smith.
The Lordship. My lady. The interested parties, my lords, my lady, would wish to contend that the relevant issues are whether the notice and affidavit filed by the appellant conformed with the notice and commencement of actions pursuant to Section 143 of the Parish Court Act, formerly the Judicature Resident Magistrates Court Act, and whether the parish court judge can exercise jurisdiction under Section 190 of the Parish Court Act if the requirements under Section 143 of the Parish Court Act have not been complied with. Lads, I crave your indulgence to indicate that we are discovering that we're at a slight disadvantage because we do not have the earlier part of the bundle, much of which was referred to by Mr. Hilton. That is before what is page 108 of the e-bundle, of the electronic bundle. We would, however, submit that two cases offer a particularly relevant focus on the circumstances which are currently before your lordships, my lady. And those two cases, my lads, are Re Pritchard and Harkness against Bell's Asbestos and Engineering Limited. And so, with your kind leave, my lads, we would wish to embark upon our arguments from this perspective.
Mr. Senior Smith, before you do that, you say that you are lacking the electronic bundle up to page 108. Is that right?
Indeed, Miller.
Do you have, however, the record of proceedings?
Yes, my lord.
So that you will have the documents, including the affidavits and the exhibits and the rulings by His Honour Judge Dale Stable and the Court of Appeal.
Indeed, my lords.
But you don't have the electronic bundle numbers. Is that the problem?
That is the constraint, indeed.
Yes. Well,
We have all the documents.
if you need to refer to any document that is there, if you let us know which document is which document it is you wish to refer, we can go to the tabs and try to find the document and the passage to which you wish to refer.
I shall do accordingly, my lord.
Yeah. Thank you very much.
Please. My lord, in Re Pritchard, and that is at tab 15, page 433 of the electronic bundle, my lord. If I may proceed, my lads, this was a particularly conscience-wrenching set of circumstances for the court, in that the widow, Mrs. Pritchard, found herself not being able, or facing the prospect of not being able to maintain an application for some relief from her late husband's estate. My lads, the court, through a majority decision, decided that, notwithstanding the, in my view, the emotional dimension to the matter, the court felt itself, by the majority, circumscribed in terms of being able to grant to Mrs. Pritchard the relief that she was seeking. But it is instructive that Lord Denning, the Master of the Rolls, on page 436 of the electronic bundle, and particularly paragraph D, intimated, my lads, that quoting, my lads, apart from authority, I should have thought that the High Court had ample jurisdiction to correct the error. It ought not to penalize the widow for a technical slip, especially when the defendants have not been in the least prejudiced by it, and indeed never raised it themselves. The court ought to allow any necessary amendment to put it right. But lads, Lord Denning also observed that, and this is on page 437, at paragraph I, if I may take your lordships to that paragraph. I quote at the sentence beginning I could understand that if the plaintiff's solicitor had failed to comply with the statute as distinct from the rules, then it might have been difficult to put it right. We are respectfully submitting that the current appeal before your lordships board reflects a situation where it is the statute that was not adhered to by the appellant in this matter. It is indeed a breach of the statute as opposed to a breach of the rules, which we would submit is a seminally significant distinction. However, my lads, we further submit that even in these circumstances, in Ray Pritchard, the breach was in relation to the rules, and yet the court by majority felt and did so rule that it was unable to effect the change that was being sought by Mrs. Pritchard. And indeed, my lads, it would be our submission that as opposed to the current appeal, in as much as it was not the statute that there was a difficulty with, the court felt itself constrained in Ray Pritchard. Well, as if I may take your lordships to the opinion of Lord Justice Option at paragraph 440 of your lordship's electronic bundle and paragraph D. Lord Justice Option intimated, my lads, that the rule is wide, and my approach to it is that the court should give it a wide construction. In paragraph E, my lads, if I may, Lord Justice Upjohn indicated that notwithstanding the breadth of the rule, it is quite clear that some proceedings are such that they are properly described as nullities, and the rule cannot be applied to them. The learned Lord Justice, my lads, in paragraph I on that same page of 440, making reference to Lord Denning in the Privy Council matter of McFoy against United Africa, said Lord Denning, who delivered the judgment of the board, dealt with the distinction between a nullity which was wholly void and something which, although improper, was voidable and capable of being cured. He pointed out that if a proceeding is a nullity, and he going over to the other page, my lad, page 441, it is incurable and cannot be validated by any subsequent act of the parties by waiver or taking some step in the action. It is unnecessary to have an order setting aside a nullity, although it may be convenient to do so. In that case, it was argued that the delivery of a statement of claim in the long vacation was a nullity and invalidated all the subsequent proceedings. But that's, we are respectfully submitting that the current appeal falls squarely in the context of a nullity which is incurable, and notwithstanding the apparent steps taken in the action by the appearance of the interested parties at the court, the interested parties by so doing could not be deemed as having waived the invalidity of the failure of the appellant to have commenced the action in a legitimate way. My lads, for completeness, The interested parties would also commend to your lordship's attention on page 444, I'm sorry, of the electronic bundle, where his lordship observed at paragraph G that there has been a fundamental failure to comply with the requirements of the statute relating to the issue of the proceedings. It was not a mere irregularity. That the all-important and essential requirement of the issue of a proceeding, whether it initiates the action or is some interlocutory proceeding in an already pending action, is that it must be issued with the seal of the issuing office. My lord, in this matter, my learned friend pointed to the submissions of the interested parties and took your lordships to paragraph 7 thereof, I'm sorry, this is one of the documents that I don't have the reference in the electronic bundle to.
It's page 96, paragraph 7 of the interested parties case is page 96.
Very well, madam. And in paragraph 7, my lads, it is the submission of the interested parties that the appellant did not intend to commence an action. And we would add, by the course pursued, made no attempt to do so. And my lads, it is the submission of the interested parties in that regard because of the inescapable fact that the appellant, of their own volition, placed the number already ascribed to the proceedings that were already underway on the document that they filed, which was headed Notice of Application with the supporting affidavit, which would suggest, in our respectful view, that the interested party, the appellant, notwithstanding being so directed from as early as 2010 in the Meta Lee Thomas Authority, did not or never sought to conform with Section 143 of the Judicature Resident Magistrate Act. Because the appellant never commenced this substantive action with the obligatory plaint that was required under Section 143. My lads, I had sought to and did make mention of the authority of Harkness, which is, my lads, before your lordships at electronic bundle page 357 to page 366, my lads. And we are respectfully submitting that in the Pritchard matter, that authority shows where the High Court, notwithstanding its inherent jurisdiction, a superior court of record, felt itself and so ruled that it was unable to go beyond or outside of the confines of the extant rule. The dissenting, very powerful dissenting judgment of Lord Denning, the master of the rolls, Millers, activated what was to be an amendment in the rule. And so, where in the Harkness matter, 3 to 4 years later, Millers, Mr. Harkness was suffering from asbestosis and was facing a situation where he may have been left without the ability to access justice, as it were, my lads. Lord Denning, in this matter, could virtually exultantly pronounce at page 363 of the electronic bundle, my lads, paragraph G, that this new rule does away with the old distinction between nullities and irregularity. So here we are now, my lads. A new rule had been put in place. And so the court, and in this leading opinion by Lord Denning, my lads, could say this new rule does away with the old distinction between nullities and irregularities. Every omission or mistake in practice or procedure is henceforward to be regarded as an irregularity which the court can and should rectify so long as it can do so without injustice. It can at last be asserted that, quote, it is not possible for an honest litigant in Her Majesty's Supreme Court to be defeated by any mere technicality, any slip, any mistaken step in his litigation, unquote. That could not be said in 1963. See in Ray Pritchard deceased. But it can be in 1966. The new rule does it. And so, my lads, we're respectfully submitting that the position of the appellant in their submissions really is aspirational, in that we would be hoping that there is a legislative change that would allow for the magistrate, the learned magistrate, now parish judge, in not dissimilar circumstances, to be able to make the change that the appellant is saying ought to have been done at the particular time. Well, it has been made very, very clear across the authorities that the resident magistrate, now parish judge, is a creature of statute. And so, in that respect, when proceedings concerning forfeiture faced a parish judge in 2010, well, I don't know if everyone is hearing because all have disappeared from screen except for Lady Black.
Right. Well, We are hearing you, I think, but we will pause and allow the IT people to speak to you in order to rectify that. You should be able to see us in these proceedings. We will adjourn for 5 minutes, which simply involves us putting our videos onto halt and remaining muted, and I will keep in touch with the IT department and with you. Thank you very much. Welcome back to this hearing before the Judicial Committee of the Privy Council in the appeal of Powell and Spence. I'm sorry that technical problems have interrupted the proceedings, but we are now in a position to resume. We are hearing at the moment the submissions by Mr. Senior Smith on behalf of the interested parties. Mr. Senior Smith.
May it please your lordship. My lady, may it please. Lads, we would submit that from as early as 2010. The proceeds of Crime Act came into being in the year 2007. And as from as early as 2010, in not entirely dissimilar circumstances, in which there was an endeavor by the state agency, the Asset Recovery Agency, there was an endeavor to have cash forfeited to the state millet. And the Court of Appeal in the authority of Metally Thomas, which is found at page 386 of your lordship's electronic bundle, pronounced unequivocally from paragraph 2 thereof, my lads, on page 386, that the appeal raises important issues in relation to the law and procedure dealing with cash forfeitures under the Proceeds of Crime Act 2007, the Act in the Resident Magistrates Court, my lads. At paragraph 25, the Court of Appeal highlighted that immediately above section 72, there's the heading, quote unquote, recovery of cash in summary proceedings. One gets a distinct impression that from section 72 onwards, the procedures laid down for cash forfeitures, as well as the powers of the magistrate when he or she deals with matters concerning cash forfeiture applications. At paragraph 28, when cash is detained under section 76, an application may be made to a resident magistrate for forfeiture of the cash seized. Section 79(1), the resident magistrate may order the forfeiture of the cash seized if it is recoverable property or be intended for use in unlawful conduct. My lads, the court further, my lads, in paragraph 33, propounded that we are without the benefit of regulations or court rules for matters that are brought in the resident magistrate's court. So in the absence of rules and regulations, it is our view that provisions relating to commencement of actions in that court must be governed by the Judicature Resident Magistrates Act and the Resident Magistrates Court rules at paragraph 34. And this is the particular point that we would wish to commend to the attention of your lordships. Resident magistrates courts, it should be remembered, are essentially creatures of statute. They are inferior courts without any inherent jurisdiction, and with only such jurisdiction as in conferred upon them by statute, unquote. Reference is made to Lindo and Hay It is therefore reasonable to think that resident magistrates courts may exercise only such powers as are given to them by statute, and that in doing this, they must act in accordance with the procedures laid down in the statute and not otherwise. At page 38, paragraph 38, Melons, the court further indicated that it is therefore clear that the magistrate may at all times amend all defects and errors in any proceeding before him or her. However, it is plain from the authority of Roe against Levy that section 190 is of relevance when there are defects or errors in form rather than substance. My lads, I would wish to, with your kind leave, just intimate to your lordships what the provisions under section 143 of the Act are. And this is to be found, my lads, at page 123 of your lordship's electronic bundle. Well, as in this regard, in relation to section 143, we would submit respectfully that the legislature provided for a regime of actions to be carried out at the now parish court surrounding the lodging of a plaint, and that, unlike the appellant submissions, is not merely a heading change or a title change. It is also important to underline, for your lordships, my lady, that we respectfully are of the view that it is only the now Parish Court Act, the former Resident Magistrates Act, which addresses the form and commencement of a claim, a substantive claim, in the Parish Court Resident Magistrates Court. And so, my lads, under section 143 of the now Parish Court Act, there are some 11 steps to be carried out involving one critical functionary within the court, and that is the clerk of the courts, my lads. And your lordship will see that under section 36 of the Judicature Resident Magistrate Act, that there is provision in terms of the duties of the clerk of the courts. And section 36 in brief speaks to the records of all civil proceedings, which the clerk of the courts is obliged to keep under his or her statutory obligation.
Do we have that section in our bundle, Mr. Senior Smith?
I'm sorry, my lads, I don't think the court is so provisioned with
Thank you.
the actual section, but if we could undertake to have your lordships receive the actual section.
If it could be emailed to us, that would be helpful. Thank you. If it goes to the registry.
Very well, minute. Very well, minute. But if your lordships could accommodate in the meantime, my reading the Act, my lads, Section 143. But before that, Section 36, my lads, for completeness. The clerk of every court shall, in all civil proceedings, cause a note of all plaints and summonses, and judgment summonses, and all other orders, and of all orders, and of all judgments and executions, and returns thereto, and of all fines, and of all other proceedings of the court to be fairly entered from time to time in a book or books belonging to the court, and to be called the minute books, which shall be kept at the office of the court. And it goes on further, my lads, to say, and such entries in said books or a copy thereof, purporting to bear the seal of the court, and to be signed and certified as a true copy by the clerk of the courts, shall at all times be admitted in all courts and places whatsoever as prima facie evidence of such entries, and of the facts therein stated, and of all the proceedings therein referred to, and of the regularity of such proceedings. So that is the provision with regard to the duties of the clerk of the courts, my lads. In Section 143 of the Act, under the heading Form and Commencement of Action, as your lordships will see on page 123 of the electronic bundle, all actions and suits in a court which, if brought in the Supreme Court, will be commenced by writ of summons, shall be commenced by the party desirous of bringing such action, or some person on his behalf, lodging with the clerk or deputy clerk or any assistant clerk at the office of the clerk of the courts, or at any court held within the parish, a plaint, firstly, stating briefly the names, and last known, secondly, places of abode of the parties, and naming a post office, thirdly, to which notices may be addressed to the plaintiff, to be called the plaintiff's address for service, and setting forth the nature of the claim, that's fourth, or of the relief or remedy required in the action, in such short form as may be prescribed by any rules in force under this Act, or as nearly in such form as circumstances admit. And the clerk or deputy clerk or assistant clerk shall note on such plaint, fifthly, the day of the lodging thereof, and shall file the same in his office, sixth, and shall as soon as possible enter the same in a book to be kept for this purpose in this office, that's the seventh, and to be called the plaint book, every one of which plaints shall be numbered in every year according to the order in which it shall be entered, and thereupon a summons embodying the matter of the plaint and accompanied by the particulars of the claim, if any, and stating the plaintiff's place of abode and address for service, and bearing the number of the plaint on the margin thereof, shall be issued by the clerk of the courts under his hand, that's ninth, and the seal of the court, 10th, and shall be served on the defendant. So, my lads, we would respectfully submit that any lodging of a plaint is to subscribe to all that regime which is set out under Section 143 of the Act. And we are respectfully submitting that in this matter, as mentioned before, the appellant went in the proceedings.
Mr. Senior Smith, I wonder if I could interrupt you because Lord Sales would like to ask a question.
Yeah, thank you. Mr. Senior Smith, can you help us with the relationship between the Act and the rules? Are the Magistrates' Court's rules made under the Act? Is there a power stipulated in the Act for the making of rules? And if so, where is it?
My lads, indeed, I crave your kind moment, my lads. If I could return to your lordships in that respect very shortly.
Certainly. At some point, it would be useful just to know how they fit together. Thank you.
Very well, my lads. So if I may, my lads, my lady, the submission is that...
Can I before you carry on?
Sorry, Lady Black.
I wondered if it was section 135 where the rules come in, possibly. That's certainly a rules committee provision, I think.
Very, very well indeed, my Lady Black. It would appear to be section 135, which I know your lordships, my lady, may be at a disadvantage, but I have here a copy of the Act, full copy, and under section 135.1, it says there is hereby established a committee to be known as the Rules Committee of the Resident Magistrates Courts in this Act, referred to as the Rules Committee. And then it goes on to speak to the provisions, my lads. Provisions of Schedule G shall have effect with respect to the constitution, operation of the Rules Committee, and otherwise with respect thereto. Subject to the provisions of subsection 4, it shall be the duty of the Rules Committee to make rules for the effective execution of this Act and of the objects thereof, and without prejudice to the generality of the foregoing. Such rules may prescribe and regulate the practice and procedure of the court, prescribe forms for the court. And it goes on, my lads. We could also undertake to have that furnished for the court's attention, my lads, by email.
Thank you very much, Mr. Senior Smith. That would be very helpful.
Before you resume, Mr. Senior Smith, it would help me to know in what respects the document which was used in this case to start things off did not comply with the requirements in section 143. I'm thinking only of those things which the plaintiff had to do and not those things which were to be done in the court office. I think we've got the document at page 8 in our bundle.
Yes.
Very well, my Lady Black. My lads, my lady, firstly, we would wish to underline the fact that the document itself was lodged with the number 77 of 2010, which was an indication that it was being filed in the already extant proceedings. We will say that the document indeed had the names and addresses of the parties. It had the nature of the claim and the relief sought. However, my lads, it was not executed by the clerk. The necessary duties were not paid. A plaint number was not assigned. The critically important reference to the summons attendant to the document to be issued by the clerk of the courts, that was not done. And we are respectfully saying that from the conjunctive expression in the Act, under section 143, this issuing of the summons embodying the matter of the plaint is part of the triggering of the jurisdiction of the court to hear the action. Unlike the chief constable authority, my lads, if I could properly cite the name. The Queen on the application of, application of Chief Constable of North Wales Police against Angel Justices, which is found at page 302 to 308 of your Lordship's electronic bundle. In that matter, my lads, the information that was filed or which was used to initiate the proceedings was headed complaint in accordance with the Act, and it was treated by the court staffers in the court's office as the commencing of the substantive action. That is, it was treated as a complaint. In this matter, the titling or heading of the notice was not in accordance with the Act, and the function of the clerk of the courts was unwittingly or inadvertently ousted by the document which was filed.
Thank you.
So in essence, the registry did not treat it as a new and originating action. But we confess that it is not, in our respectful view, in keeping with the hoped for modern practice. However, in our submission, my lads, it is the existing law, and all that His Honor Mr. Dale Staple did in this matter was to act in accordance with the existing law, that is section 143, and accepting that notwithstanding section 190, which allows for corrections of defects, he was confined by the fact that no commencement of proceedings had taken place, and as such, there was nothing in the form of a legitimate action before him that he could have gone on to make corrections to. My lads.
Thank you.
My lads, we would wish to underline that the parish court is indeed a court of very limited jurisdiction, and also to point your lordships to the fact that in forfeiture matters before the courts here in Jamaica, the plaint is the decided document that is to be, or that has been used or opined as being the appropriate document to initiate such substantive actions. I take your lordships respectfully, with your kind leave, to page 463 of the electronic bundle, my lads, just as it is illustrative. And this is a matter which was before the Supreme Court here in Jamaica by way of judicial review. Interestingly, a matter argued by my learned friend, Mr. Hilton, and in which the court ruled, first at paragraph 20, on page 471 of the electronic bundle, my lads, that following precedent that the resident magistrate, now parish court judge, is a creature of statute. To that extent, all the powers of the parish court judge must be derived from some statutory rules made thereunder. And on to specifically paragraph 30, my lads. The application for forfeiture is this is at page 474 of the electronic bundle, my lads. The application for forfeiture is a separate action, civil in nature, and begun by plaint, my lads. My lads, we respectfully submit that in relation to, just to go back very briefly to the Chief Constable matter of on pages 302 to 308 of your Lordship's electronic bundle, that we depart from the appellant in their contentions that there is any degree of informality to the Resident Magistrate Act, or now Parish Court Act in Jamaica, my lads. And so in that particular respect, the legislation which was the issue before the court in the Chief Constable matter is, in that specific regard, different from what engages, that which engages your lordships today. We also say, my lads, respectfully, that it is not our understanding in relation to the duties which are payable at the commencement of parish court proceedings that any undertaking is ever made by counsel or by any litigant to pay those duties. And in that respect, we say that there is a demonstrable difference between what obtains in the Supreme Court of Jamaica, where a claim form or a fixed date claim form can be filed without the required stamp duty being paid, with counsel or the litigant giving an undertaking to the court to make amends and have those duties paid. That is the practice in the Supreme Court, my lads, and particularly under the new civil procedure rules of 2002, my lads, which largely brought the Supreme Court practice into the quote-unquote modern era, but there is no such facilitating amendment in the parish courts on our understanding of the practice in the parish court. In the Alexandrine authority cited by my learned friends, my lords, at page 324 to 330 of your lordship's bundle, respectfully submit that there is a distinction between those proceedings before your lordship's board and this current appeal, my lads, which particularly is that matter was in the Alexandrian, Austin and others against Jean Hart was properly begun or commenced using the appropriate procedure, and it was also in the right court. It was only a mere premature commencing of the action, but there was no possible prejudice against the respondents in that matter, blood, whose duty it was to inevitably bring the action in any event. In this matter, my lads, currently before your lordships, there is a substantive right which has been accrued by the interested parties, given the time cap or the limitation which is included in the Proceeds of Crime Act of 2007, my lads, wherein matters are to be adjudicated upon within the 2-year limit, my lads. And we respectfully submit that the interested parties would have been, to the extent that it was possible, for amendment by the learned resident magistrate, would have been prejudiced and would continue to be so prejudiced currently, my lads. My lads, we commend to your lordship's attention and on your lordship's page 11 of the interested parties submissions, my lads. I'm not so sure what page it is, as I expressed earlier in relation to the electronic bundle.
Which paragraph are you referring to?
Paragraph 19C, my lads.
Thank you.
19 appears on it. Very well, my lads. We had made mention of hardness. Very well, my lad.
Thank you.
We had made mention of hardness before. Thank you, my lad. And we underscore now Hannigan and Hannigan.
Yes.
Demonstrate differences in how matters are treated, because in this matter, there was a commencement document involved in the form of a petition. At D, Earl and Kremin and others, we say that another commencement document was used.
Yes, you're referring to paragraph 23 of your case on page 103. Yes.
Very well, my lads. We are looking, it is page 11 of the interested parties submissions.
Yes, it's paragraph 23 D, C and D, I think, yes.
Yes, indeed, my lads.
Thank you very much.
And we also highlight for your lordship's attention that other matters, my lads, for example, the Eldemire and Eldemire Authority, as well as the Valda Ormsby Authority in the Supreme Court here, that in both those decisions, the claimants used a commencement document, being an originating summons and a fixed date claim form, respectively, to initiate the proceedings.
Mr. Senior Smith, what was the name of the second case, please?
Valda, VALDA, lads, Ormsby, ORMSBY against Worldwise Partner Limited, lads. And this is in paragraph 20 of page 11.
Thank you.
I think it will be your lordship's paragraph 24, but it is our paragraph 20, my lads. But it's a paragraph which begins, it is submitted that the parish court judge or the parish judge was correct in forming the view that he was without jurisdiction to cure the defect, as there were no proceedings.
Paragraph 24.
Yes, my lords. In the Westminster Bank, as I seek to wrap up my submission with your lordship's kind leave, Westminster Bank Limited and another, and Edwards and another, which is at page 475 of your lordship's electronic bundle. It is again showing, my lads, that even where it is a court of appeal that is found to have acted without jurisdiction, in this case, reversing a finding of fact made by the learned trial court, where both parties had duly accepted such a finding of fact by the trial court, and additionally, neither party before the court had appealed against the conclusion in that particular matter that a multi-lease existed. The House of Lords was able to reverse that decision by the Court of Appeal, my lads. And their lordships were keen to adumbrate that mere acquiescence, and this is on page 13 of the interested parties submissions minutes. Mere acquiescence does not give jurisdiction. End quote. But in wrapping up our submissions, we would respectfully say that the position of the magistrate in Jamaica, the resident magistrate, now parish court judge, is largely reminiscent of where the court was located before the change. The Superior Court was located before the change of the rule in the Pritchard matter. And where we would wish to go in the modern approach or practice is with a rule change legislatively. I'm sorry, not a rule change, but a statutory change, a change in the statute by the legislature, by Parliament, to provide an amendment to the now Judicature Parish Court Act in order to imbue the learned parish court judge with the competence to make the amendments, the nature of which is being submitted by the appellants in this matter. But unless I can assist the board further, those would be my submission.
Mr. Senior Smith, thank you very much. I will check with my colleagues to see if there are any further questions. I don't see any. Thank you very much indeed. Mr. Hilton.
Thank you, my Lord. My Lord, may I first give a further response to the question Lord Hodge asked me in relation to the discretion question. If I could refer your Lordships and your Ladyship to page 32 of the electronic bundle, which is the notice of appeal to the Court of Appeal. The orders sought at page 33, paragraph 5, included orders that the parish court judges ought to be set aside and that the notice and affidavit be treated as the plaintiff and particulars of claim. Now, that notice of appeal, because it was initiated as an appeal by way of case stated, your Lordships will see on the following page that's signed by the parish judge. Now, of course, the parish judge wasn't agreeing that those orders should be granted, but I think that at the very least, he was content for the appellate court to exercise his discretion if he thought otherwise. So I bring that to attention as it might assist your Lordships in your decision making.
Thank you.
The other matter, if I may address briefly, my Lord. My learned friend took you to section 36 of the Act and to the provisions in section 143 that refer to the things that the clerk and the registry were to do. And in that regard, I would note that paragraphs 49 to 51 of our written case address that issue and rely in particular on the decision of the House in the Manchester Stipendiary Magistrate case. that the failure, in summary, my lord, the failure by the registry to take steps can't make the matter a nullity. One ought to look at the requirements for the claimant and the actions the claimant took or did not take. And finally, my lord, the point my learned friend made repeatedly about the amendments to the legislation in the UK. I will submit that we have no amendment in the present case because the power is there now in section 190. And so the issue, respectfully for this panel, for your office board, is whether that section, properly interpreted, gave the parish court the power to make the necessary amendments. And in our submission, it did. And there's therefore no need for further legislative action to permit that. Okay. And subject, my lords and my lady, to any questions, those would be our responses.
Mr. Hilton, thank you. I'll check with my colleagues whether there are any further questions. I don't any. Well, in those circumstances, so Lady Black, did you want to? No, no. In those circumstances, the board would like to thank council for their succinct and focused submissions. And also we would like to thank those who assisted them in preparing and presenting their cases in this appeal. The board will take time to consider what advice it will humbly tender to Her Majesty, and the board will now adjourn. Thank you.